Hello guys, welcome back to my YouTube channel. I'm Salwa. Today I'll be talking about the fact the court to consider before coming to the conclusion that a marriage has broken down irretrievably. It's actually not enough to simply say that I am no longer interested in this marriage. The law requires proof of specific fact before the court can come to the conclusion that a marriage has broken down irretrievably. So like I said in my previous video, there's only a sole ground for divorce in Nigeria, and the sole ground is that the marriage has broken down irretrievably. However, before the court can come to this conclusion, the petitioner is required to prove at least one of the facts listed under section 15(2)(a) to h of the Matrimonial Causes Act. So let's dive into these facts together. The first fact is willful and persistent refusal to consummate the marriage. So what this simply means is that the court may actually grant a dissolution if one of the spouse deliberately refuses to consummate the marriage. Consummation refers to engaging in sexual intercourse. So if your spouse continuously and without medical justification refuses to consummate a marriage or refuses to have any sexual intercourse, sexual relations with you after the marriage, then it can actually serve as a proof that the marriage has broken down irretrievably. So you have to know that the non-consummation must actually begin from the date of marriage. It is actually immaterial that you guys have been having sexual intercourse before the date of marriage. So it must start from the night of that marriage, the night the marriage was celebrated, up to the time of instituting the petition in court. The second fact is adultery and intolerability. What this simply means is that the court may actually dissolve a marriage if the petitioner proves to the court that since the marriage the respondent has committed adultery and the petitioner finds it intolerable to live with the respondent, that is the spouse. So the petitioner must actually it must actually show the court that the adultery truly occurred. So the adultery can actually be inferred from different circumstances. It can be from direct proof, that is the confession by the adulterous spouse or the paramour. The paramour is the person that the adulterous spouse committed adultery with, and it can also be from an eyewitness testimony. It can also be inferred from circumstances, that is your spouse being in a secluded place with any other person other than you, and provoking WhatsApp messages, the birth of a child and the like. And also know that it is not enough that you are proving adultery to the court. You also have to prove to the court that you find the act of adultery intolerable to live with. So you guys will actually be agree with me that there are some spouses that actually live with their adulterous spouse. They live with their spouse even after committing adultery. So you have to show the court that you've not condoned your spouse the adulterous act. So you have to show to the court that okay, you find it intolerable to live with your spouse after committing the adultery. The third fact is behaviour that makes it unreasonable to live together with your spouse, often known as cruelty. So what this simply means is that before the court can come to the conclusion that a marriage has broken down irretrievably, the petitioner must actually prove to the court that since the marriage the respondent, that is the other spouse, has behaved in such a way that the petitioner cannot reasonably be expected to live together with the respondent. So this behavior could be cruelty, violence, abuse, constant neglect, serious irresponsibility by the other spouse, the other spouse constantly being in a state of drunkenness. This fact is actually broad and it is often relied upon in Nigerian divorce petition. The fourth fact is desertion for a continuous period of 1 year immediately preceding the presentation of the petition. What this simply means is that before the court can come to a reasonable conclusion that a marriage has broken down irretrievably, a spouse must have intentionally abandoned the other spouse without any good reason, and without the other spouse's consent, and with an intention of ending the marriage. Let's take for instance, if a husband leaves the matrimonial home by January 2023 and without telling the wife where he's going, stops communication and also refuses to provide maintenance, and by February 2024 if he still has not returned or resumed the marriage, the wife can actually rely on desertion as a fact to prove that the marriage has broken down irretrievably. The fifth fact is living apart for a continuous period of 2 years and that the respondent does not object to the dissolution. Here, the petitioner, that is, the petitioner and the respondent must actually consent to the dissolution. They must, the two of them must actually agree that okay, they actually want the marriage to be dissolved. So the consent is actually paramount. So you must, before the court can actually come to the conclusion that your marriage has broken down irretrievably, you have to show the court that you have lived separately from your spouse for 2 years preceding the presentation of the petition. The sixth fact is living apart for a continuous period of 3 years immediately preceding the presentation of the petition without the consent of your spouse. What this simply means is that even without the consent of the respondent, your spouse, a spouse that actually won divorce, can still petition the court successfully. So the law recognizes that 3 years separation is actually a very strong evidence to show that your marriage has broken down irretrievably. I feel the reason for this is that the reason for saying that you don't need the consent of your spouse is that the law actually wants to prevent a spouse holding the other spouse hostage in an obviously dead marriage. Seventh fact is failure to comply with restitution of conjugal rights. But before the court can dissolve a marriage relying on this fact, there must have been a prior court order directing a spouse, the respondent in this case, to resume cohabitation, which is known as restitution of conjugal rights. So if the respondent disobeys the court order and the petitioner feels that he or she is no longer interested in the marriage again, the petitioner can actually petition the court and rely on this fact to prove that the marriage has broken down irretrievably. And the last fact is presumption of death. If your spouse has been missing for 7 years or more and there is no sign of his or her return, the court will presume the spouse dead, and the court can actually dissolve your marriage based on these facts. If this video is beneficial to you in any way, kindly like, comment, share and subscribe to my channel.